What happens if you try to exercise your right to remain silent and the cops just ignore you? We've all seen the movies where cops recite you your Miranda rights, but here is the real truth. Cops use sneaky tricks to sidestep your rights, and most people have no idea how to respond to them. I'm Jeff Hampton, former prosecutor turned people's lawyer, and in this video, I'm breaking down the 5 tricks cops use to undermine your silence, and more importantly, what you can do to protect your constitutional rights during any encounter. Before I jump into the cops' first trick, let's remind ourselves why your Miranda rights are so important. The landmark 1966 U.S. Supreme Court, Miranda versus Arizona, established the rule that you have a right to remain silent during police questioning. It was meant to protect all Americans from having to submit to the police because they think, under the circumstances, they had no other choice. If police don't recite these rights to people who are in custody during interrogations, anything they say can't be used against them in court, right? Well, in theory. But the problem is the United States Supreme Court has chipped away at this rule over the last 5 decades, to the point now they've carved out so many exceptions and loopholes for cops to work around this that it's very much limited its real application. You have to remember, prior to Miranda versus Arizona, Chief Justice Earl Warren pointed out that cops were actually trained to, quote, persuade, trick, or cajole a suspect out of exercising his constitutional rights. In fact, he quoted specifically from police manuals where he said, and I quote, "It encouraged officers to deprive suspects of every psychological advantage and to create an atmosphere that suggests the invincibility of the forces of the law." In fact, Chief Justice Warren pointed out that prior to this rule of Miranda versus Arizona, sometimes people were actually tortured during police interrogations. The Miranda decision changed American criminal procedure, or at least it was supposed to. The problem? Cops started using tricks created from case law. Trick number 1, cops can violate your right to remain silent if they claim you were inconsistent in what you said. In 1971, the United States Supreme Court ruled in Harris versus New York that prosecutors could use illegally obtained confessions against someone to discredit their testimony, even though they couldn't use them as actual evidence of their guilt. For example, if a suspect said before receiving the Miranda warning that they had pulled the trigger, but then later, after Miranda had been read to them, they said that actually someone else had pulled the trigger, now the prosecutor could use the illegally obtained confession to show that they changed their story. Creating this loophole, Justice William Brennan said in his dissent, and I quote, "undid much of the progress made in conforming police methods to the Constitution. It is monstrous that courts should aid or abet the law-breaking police officer." But that was just the first trick police used to get around your right to remain silent. Trick number 2, cops can actually ignore your right to remain silent by changing the definition of interrogation. 10 years after Harris versus New York, the Supreme Court further weakened your Miranda rights in the case Rhode Island versus Ennis. Providence police arrested Thomas Ennis for a suspected armed robbery. He then said he wanted to exercise his right to remain silent and his right to an attorney. As a trio of officers began to drive Thomas Ennis to the station, they began to talk to each other. They started saying out loud so that Thomas could hear it, that because the crime scene was near an area where kids with disabilities went to school, it would be terrible if those kids somehow found that shotgun first. Ennis, overcome with anxiety, apparently interrupted the officers and led them to the shotgun. In court, Ennis argued that this whole charade put on by the police violated his Miranda rights, specifically because he not only requested a lawyer, but also requested his right to remain silent. The justices agreed that the definition of interrogation included, and I quote, "actions that police should know are reasonably likely to elicit a response." Incredibly though, the justices decided that Ennis had not been interrogated, even under this incredibly broad definition. So here's where things got bizarre. The court then said, because the police could not have known that Ennis was, quote, particularly susceptible to the concerns of disabled children, then there's no way that the police could have known that their performance would have prompted Ennis to speak up. The problem here? You say, come on, Jeff. Look, the guy knew where the shotgun was. What's the problem here? Here's the concern. Police know. It is textbook police procedure and process here to appeal to someone's decency and honor to have them speak up. In fact, these are common interrogation techniques that are taught to police officers and detectives. So if they're taught these techniques, then it seems reasonable that it would make people talk. Check out what Justice Stevens said in his dissent. He said this. He said the decision basically gives police a green light to ignore requests for lawyers so long as they are careful not to punctuate their statements with question marks. Now, as dumb as this trick is, it's nothing compared to the next trick. Trick number 3, the right to remain silent can only protect you if you are not silent. This is perhaps the most absurd Supreme Court case destroying your Miranda rights. In the 2010 Supreme Court case, Burgess v. Tompkins, the Supreme Court presented Tompkins, a suspect, a written summary of his Miranda rights. Thompson was afraid to sign anything that the police put in front of him, so he refused to sign this form acknowledging his Miranda rights. Instead, Tompkins remained pretty much silent, occasionally nodding his head and maybe saying a yes or no, but not really saying much of anything for a full 2 hours and 45 minutes of an interrogation of a detective asking question after question and making accusation after accusation. Finally, after beating Tompkins down for over 2 hours and 45 minutes, the detective asked Tompkins if he ever prayed to God for forgiveness. Tompkins choked up for a moment, looked away, and barely said yes. This one word was used as the basis for an admission, which then went to court where he was sentenced to life in prison. Now, if you remember, in the original Miranda v. Arizona case, Chief Justice Warren said that the police must stop all questioning if a suspect indicates in any manner that he wishes to remain silent. In Tompkins, the court flipped that principle on its head and gave them a trick to get around your right to remain silent. Justice Kennedy said that silence by itself was not enough to indicate to a detective that you wished to remain silent. So, the only way to take the benefit of your right to remain silent is that you must state it unambiguously that you are exercising your right to remain silent. The court also said that because Tompkins sat there fairly silent for a 3-hour interrogation and then allowed one word to come out of his mouth, the court said that was enough for the police to believe he had waived his right to remain silent. The problem with all of this? Put yourself in this guy's shoes. Here you are, unfamiliar with this environment, probably handcuffed, afraid of exactly what will happen if you don't cooperate. I've seen it happen thousands of times. Police will actually be in an interrogation room with someone and claim that they're always free to leave whenever they want to. But in reality, at no time do you ever feel like you're free to leave, and the cops absolutely don't treat you like you could just get up and walk out. The Tompkins ruling uses justifiable feelings of powerlessness to render people powerless. Justice Sotomayor said that the Tompkins decision would effectively encourage cops to do what? This is what she said, and I quote, "Question a suspect at length, notwithstanding his persistent refusal to answer questions, in the hope of eventually obtaining a single inculpatory response." She also pointed out the cruel irony of the Tompkins decision, that to now exercise your right to remain silent, you have to choose now to not remain silent. To think it couldn't get any worse, the Supreme Court then took this lunacy even further with this next trick. Trick number 4, cops can use your silence against you. In 2013, the Supreme Court took that Tompkins case logic even further with Salinas versus Texas. Here, the court said that if a person who isn't in custody refuses to answer a police officer's questions, that silence can actually be used against them later in court if they didn't invoke their Miranda rights that they were never even told about. As Justice Stephen Breyer put in his frustrated dissent, he said, I quote, "How can an individual who is not a lawyer know that these particular words are legally magic?" Here's the part that blows me away, because Justice Alito, in his majority opinion, stated this, and I quote, "Treating silence as an exercise of the right to remain silent would, quote, needlessly burden the government's interests in obtaining testimony and prosecuting criminal activity." By instituting a police-friendly rule during interrogations, the court drew a line in the sand. They made it perfectly clear that they would rather prefer and make a preference for the police over the constitutional rights of U.S. citizens during police interrogations. Now, many people say this is good. It will help get all those guilty people off the streets. And maybe that's true, but let me ask you a question. What about all those poor people who are unsophisticated and end up being duped by all these police tricks and lies, and they end up wrongfully convicted and going to prison for the rest of their life? Finally, trick number 5, Courts will protect police if they choose to ignore your right to remain silent. Now, I have to admit, this is a tough case to swallow. In the case Vega versus Teco, the Supreme Court ruled that you cannot seek money damages against a police officer who fails to read you your Miranda rights and then tries to use those illegally obtained statements against you in court later. This case was absolutely horrible. In fact, if you go back and study it, you'll see that the record was absolutely clear that when Deputy Sheriff Carlos Vega, he had actually violated Terrence Teco's rights because he had obtained information from Terrence Teco illegally and manipulated him and never read him his Miranda rights. This led to Deputy Vega trying to use those illegally obtained statements against Teco in trial. And he went to trial. He had to hire a lawyer. He had to pay for all of this, go through all the pain and anguish and suffering of being accused of something he didn't do. And later he was absolutely acquitted. The problem with that is he suffered all this damage. He still lost his job. He lost his reputation as a result of it. So he felt he had a right to sue the deputy for violating his constitutional rights. Teco then brought a Section 1983 federal lawsuit against this deputy for violating his constitutional rights. Unbelievably, the Supreme Court ruled that Teco could not bring this civil damages claim against the police officer, against this deputy, because, I'm going to read to you, quote, allowing it would place an extraordinary burden on police when it comes to their investigative work. Qualified immunity strikes again. Underlying each of these cases is a theme from the Supreme Court. For whatever reason, the Supreme Court believes this undying faith that police officers are always going to follow the rules and never trick people or get unlawful or false confessions from people. If you actually study the evidence, though, this trust they are placing in the police is not well founded. Let's take the 1984 New York versus Quarles decision as an example. In that case, the police found a handcuffed suspect's empty holster and asked him where the gun was. Although the officers never read Quarles his rights, they were able to use his statements against him at trial. How? Because the court explained, and it's just hard to believe, but I'm going to read to you what they said, that complying with Miranda would put police in the untenable position of choosing between protecting and serving on one hand and safeguarding the civil rights of someone on the other. I want you to think about this. This decision creates for the police a very perverse incentive. Why not just ask questions to someone before you ever read them their rights in the name of public safety? This allows police officers to cut corners in the name of an emergency situation of public safety. Now, the amazing thing is the Quarles court, the majority there, if you read the opinion, they recognize this could be a concern, but they literally basically say they think everything will work itself out with the police. Let me read to you what Chief Justice William Rehnquist actually said in his opinion. He said, and I quote, "We think police officers can and will distinguish almost instinctively between questions necessary to secure their own safety or the safety of the public and questions designed solely to elicit testimonial evidence." Now, I think I mentioned this earlier, but you do know that the police are allowed to use trickery, lies, and manipulation in order to gain any type of information from you they want. I can't possibly respond to Justice Rehnquist any better than Justice Marshall did in his response. And I'm going to read it. Quote, "The majority should not be permitted to elude the Fifth Amendment's absolute prohibition simply by calculating special costs that arise when the public safety is at issue." You might say, wait, Jeff, does this mean we have no rights at all? There are a few small glimmers of hope when it comes to our rights. In 2004, the Supreme Court did strike down a new trick cops tried to come up with to violate your Miranda rights. In that case, cops would ask you questions first, then give you your Miranda warnings, then turn around and ask you to repeat what you had just admitted to before your warnings. There, Justice David Souter very clearly stated that this was an obvious attempt by the police to undermine your Miranda rights, and they overturned it and call it a violation of your constitutional rights. So finally, how do we protect ourselves from all of these ridiculous tricks by the police? Number one, as soon as police begin questioning you, you immediately exercise your right to remain silent. You say, "Officer, I exercise my right to remain silent." Then say nothing else at all. Remain silent. Number two, in addition to exercising your right to remain silent, add on your next right, your right to an attorney. Officer, I exercise my right to remain silent, and I exercise my Sixth Amendment right to counsel, and I will not answer any further questions unless my lawyer is present. And then remain silent. As we learned back in trick number 2, if you exercise your right to remain silent and then start talking again, cops can start all over again and use everything against you. Number 3, if police refuse to let you leave and continue to detain you, ask, Officer, am I free to leave? If they say no, re-exercise your right to remain silent and to have an attorney present. If they say you are free to leave, get out of there. Finally, number 4, remember cops cannot be held civilly liable for violating your Miranda rights. So, never fall for any deal or any promise ever made to you by a police officer, because not only are they allowed to legally lie to you, we now know they can actually ignore your constitutional rights and still have qualified immunity. I want to remind you that the purpose of our Miranda rights is to protect human dignity. It's to ensure that the protection of your legal rights does not rely upon your legal knowledge. But we now know that the Supreme Court has spent decades hollowing out that so-called promise. Today, only people who know their Miranda rights and how they apply and when to exercise them and how to exercise them can hope to enjoy the protections they provide. For everyone else, they're on their own. Speaking of knowing your rights, what if cops confront you claiming they know you have a gun and they want to see your gun? Check out this next video where I break down your rights and how to protect yourself if cops come knocking demanding to see your guns. See you over there.